Electoral Administration Amendment Bill number 2. The question is that Part 1 stand part. The Honourable Leanne Dalzell.
Make a very brief call in order to get on the record of the House the understanding that we have on this side of the House with respect to the supplementary order paper which has been or will be moved by the Minister, which inserts a new clause 5A, amending as it does clause 22 and 23 of the bill. Yes, a new section 22, of the Act. Since the time that we were consulted over this, and I want to put on record our thanks to the Minister for having a very open and consultative approach on this piece of legislation. It is important when it comes to electoral administration to get these technical matters correct, as it does for the more substantive issues in relation to electoral law reform. But when I looked at the departmental report around the provisions, which is to change the definition of an adjoining district for the purposes of the appointments of registrars of electors, the departmental report states, we note that the EEC has already carried out a restructuring exercise aimed at moving to a regionalised structure. This has seen the effective disestablishment of a number of Registrar of Electors positions. The restructuring has been challenged by the Engineering, Printing and Manufacturing Union in an application for judicial review. We understand that the application, which is currently before the courts, alleges that the restructuring contravenes the existing requirements of Section 22 of the Act. Amending the Act before the court case is concluded has a number of implications that require careful consideration. One possible effect would be to limit the remedies the court could offer if the application for review is successful. The existence of the live legal proceeding supports our earlier conclusion that consideration of the structural change proposed by the EEC should be deferred until a more appropriate time. And then there's further discussion about various approaches to that the Electoral Commission have adopted on that. But I would like the Minister to take the opportunity that this debate allows to confirm on the record of the House that this technical amendment is supported by the EPMU and will not prejudice their case.
The Honourable Simon